This is the Scott County Board of Adjustment. I hope everybody who intends to speak has signed in. First item of business is review and approval of the minutes from the January 2nd meeting. Has everyone had a chance to look at them?
Make a motion to approve.
Second.
Motion by Mr. Cannon, second by Mr. Lancaster. All in favor?
Aye.
Okay. You need to sign those before you. At this time, our attorney will swear in everyone who wishes to speak. So if you'd stand and raise your hands.
Raise your right hand, please. Everyone signed in to speak. Do you swear or affirm the statements you're to make tonight are the truth, the best of your information and belief? Thank you.
Okay, the only item on the agenda tonight is the application of S-2-14 by Sweeney Properties requesting a conditional use for a lawn care business at 390 Paynes Depot Road in the A1 district. If our planner
Do you want me
would like to
Okay.
tell us what this is all about.
All right, I'll give you the background on it. This is a request for a conditional use permit at 390 Paynes Depot Road. This is a property that's had industrial / agricultural uses on it for a long time. There's two Board of Adjustment cases on the property. The first one that we have record of is in 1998 for a determination on lawfully non-conforming use on the property for a sandblasting, Fourth Street Fertilizer Company and the Bluegrass Sandblasting Company. And the board at that time determined that it was a lawfully non-conforming use and could continue. In 2001, the property was sold to Wright's Welding, and Wright's Welding came to the board for a conditional use permit and was approved at that time. And the previous, the 98 non-conforming use ruling had a few conditions in it. One of them was that there should be no outdoor storage of materials, and any loading or unloading should occur, and then everything should go inside. And then the Wright's Welding conditional use added those conditions to that, so they continued to say, we won't use the outdoor areas except to load and unload materials, and then we'll get it inside. So those are the only two cases on the property. Any conditional uses do not transfer from owner to owner, so they don't stay with the property. So whenever there's a change in use or ownership, the new owner or use has to come back to the board for a conditional use permit for their use. We don't patrol the county to find changes of use, so a lot of times we're not aware of change in ownership. So this went under the radar till I got a complaint in December that there was a use there that wasn't following the previous conditions of approval. So we went out and investigated, and there was a change in ownership, and we saw that there was a new use and new owner. So I sent a letter saying you'll have to come back to the Board of Adjustment to get a conditional use permit for your use. So that's where this started. So the conditional use permit request is for a landscaping and snow removal business, Al's Complete Lawn Care. It's been operating since 2007, but once we're notified of it, that's when we informed them they'd have to get a conditional use permit. The site was pretty much in its current condition when they took over and started operating. There has been one change that I'm aware of, and there may be others, but one is the salt dome and the salt area that was added at some point since 2007. There have been some issues over time with parking. There was an accident along the railroad right of way. There's a large number of employees with this business, so there has been issues that I'm aware of with parking off-site and around, and I've seen pictures of trucks parked outside the fenced area. The other, typically when we look at conditional uses, we look at access, we look at effects on adjoining property owners. We usually look at outdoor storage, hours of operation, and any other impacts that we see that the property might have on adjoining owners. And we try to introduce conditions that will help alleviate those impacts to the adjoining property owners. Landscape and lawn care businesses have been approved throughout the county as conditional uses. There's some on 25 and there's some in other areas. It is, although it's not a specifically listed use under conditional uses, it is an kind of an ag-related rural use that has been permitted as a conditional use permit. So that's why they're going, we're requested to go that route. The few issues other than parking that I see are one, the outdoor storage on the property, since there was a previous condition of approval that there be no outdoor storage to the degree possible. Most things, most parts of the operation should take place indoors. That was part of previous conditions for previous uses. I know this one is different, but I think the main thing with this landscaping business is, one, there's a lot of parking involved. Employees come to the site, they park their vehicles, and they pick up fleet equipment or plows or what have you, landscape equipment, and then they drive and they do work in the area. So they're off-site for most of the day, and then they come back, and then there's vehicles and equipment parked on-site overnight. So there's the one major issue I see is with parking and storage of equipment. The other issues on site, I would say, are the gas tanks and fuel tanks that are stored outside that are used to fuel the equipment and trucks. And then because the site is largely gravelled, any stormwater runoff or storage of materials outside drains, since it drains down to the farm. If there are any issues with pollution off-site or drainage issues off-site, that would be another concern. I'm not aware of any, but I'm not out there all the time either, so I don't know exactly what those issues are. We are recommending approval because these uses are fairly common and have been permitted in the past out in the county, but we recommended the 9 conditions of approval that I put in my staff report, and that's to address the issues that we're aware of and that have been, these are fairly common conditions that we put on businesses out in the county that are ag-related or that are similar to this use. The first one is that this conditional use permit doesn't exempt it from this business from meeting all other requirements of zoning, and that would be setbacks, building permits, and all other conditions that would affect an A1 piece of property. Number 2 is that all vehicles and equipment should be stored inside the fenced yard, and the property is fenced along the street and along the railroad. And along the access easement, it's accessed by an easement across 3 residential lots in the front, that all storage and parking occurs inside the fenced area. That the subject property be subject to any local, state, or federal requirements if applicable for the above ground petroleum tanks. And I've been trying to contact the state fire marshal to see if there are any permits required from the fire marshal's office, and called him multiple times. He hasn't gotten back with me. So if there are, we can enforce or make sure that the proper permits are obtained for those. 4, that the applicant maintain the existing access easement open and clear of vehicles and material. 5, the applicant receive approval from the local environmental health department for the septic system being utilized on the property. I'm not sure of the number of bathrooms or the use of those facilities by the workers, but it is on private septic systems, so we want to make sure the health department is okay with the use on the property. Number 6, there should be no sales to the general public of landscape plants or material, so it's not, this approval isn't for a retail landscaping business. 7, all pesticides, chemicals shall be stored inside the building under roof. Storage of miscellaneous plows, spreaders, or related landscape equipment and materials shall be inside a building or screened from the road. And there is an area in the back of the property that's pretty well screened from the road that could be used for storage. Number 8, the applicant shall return to the Board of Adjustment prior to any change which affects the approved conditions. And number 9, the applicant shall comply with all, like number 3, shall comply with all local, state, and federal permits or regulation, and shall provide a copy of all permits to the Planning Commission for our file. The only other thing I'd add is about runoff on the site. I did contact the Division of Water Permitting. Again, they didn't get back with me either, so I don't have an answer from them, but it's someone that we could rely on for information about the water quality of the creek and if there's been any impacts related to this business. It's something we could follow up on, but I don't have anything from them.
Has there been any new construction on this property since the last conditional use permit was granted?
I think the salt dome was added, but I think the rest of the buildings were all
So the
there
septic
when they
tank was there
purchased.
before?
Yes. Mhm. Yep.
And you may have sort of answered my question already, but you all had suggested that you construct a filtration berm.
Yeah.
And then, but it didn't make your list of conditions. Is that because you hadn't heard back from Division of Water yet?
Yeah, I didn't know if it was a problem or not. If it is a problem, that could be one solution to filter out anything that did get mixed in with the rainwater, and
Okay.
there might be a way to. There are ways to filter and capture that stuff.
Sure.
That's all I had, but I can answer
So
questions.
was that one of the conditions?
It wasn't the berm.
Yeah.
No, I did not add that as a condition, because I didn't hear back from the Division of Water about the water quality out there, if it was an issue or not.
Shouldn't it be one of the conditions then?
It could be, if it's a problem, yeah, but,
We don't know that it's a problem yet.
yeah, you could temper it or add language to it that says, if it is a problem, that they work with the Planning Commission engineer to
determine.
develop a
Plan.
engineering solution to solving the problem.
Yeah, and then
Or some such-
if they don't solve it satisfactorily, that you could bring it back before us to review the permit, right?
Yeah.
Okay, does the applicant have anything to add to this presentation?
Yes, ma'am. May I make a statement?
Yes.
Madam Chairperson, members of the board, and Mr. Perkins, my name is Skip Gaines, and I'm an attorney over in Frankfurt, and I've been helping Alan with this application, and I would like to make a few comments if I could, and I won't take long. Let me say, first of all, in response to your question, the only building that has been put on the premises since Mr. Sweeney bought the property with his family in 2007 is the salt dome, and that is shown in Exhibit 9 to our application. As far as the septic system, I'm just addressing, first of all, Mr. Kane's comments. There are 3 toilets on the premises. They're all located in the main building, the office building. It's noted, I believe, on the plat. and they empty into one septic system. That septic system, according to Alan Sweeney, who's sitting here on the first row, advised me that it was fully checked and pumped a year ago, and according to Monroe Plumbing, is fully operational and fine. As far as the berm is concerned, let me say first of all, with respect to the staff report, we are willing to do all of the recommendations of the staff, and if the board determines that a berm is necessary or may be needed, obviously we'll be willing to work with the engineer for the planning department and take care of that situation. So we don't have any problems with anything Mr. Kane's staff has recommended. I would note that in the staff report, Mr. Sweeney purchased the property in 2007, and there's a couple issues I think are sort of important, and that is if you'll look at Exhibit 2 to the application, I believe it's Exhibit 2, you know, that was the listing agreement that the realtor provided to the Sweeneys at the time they bought the property. And if you'll notice on page 1, the very first page of that, up by the photograph, it says that the property can fit many uses, including construction, maintenance, various trades, storage, lawn care, and horse-related businesses, and then has down at the bottom under current zoning that it's light industrial non-conforming. Mr. Sweeney was given a copy of this plat back in 2007, and I was not able to copy that and get that in the application. But it is a conceptual development plan for a zone change from A1 to I2. And it's dated October of 1997. When I talked to Mr. Kane about this, he indicated, I believe he said that an application had been filed but withdrawn. Am I stating that correctly?
Yes.
Okay. So the only reason I bring this up is that it's no excuse for a 21-year-old man who bought this property. He should have checked the zoning, but he didn't. And my only point in mentioning this is that, you know, he really believed with all sincerity that the property was zoned for the use that he's using it for. And I don't want the board to think that he just went out there and knew it was agricultural and just did what he wanted to do out there. Also, I would like to sort of confirm what Mr. Kane said. This property has been a lawn care business, mowing, lawn care, lawn maintenance, snow removal since 2007. In 2001, it was owned by, I believe, Mr. and Mrs. Wright. I believe they operated a welding service there. Mr. Kane has talked about going back to 1998 when 4th Street Fertilizer and/or Bluegrass Sandblasting operated out of there. When we checked the records in the real estate office, the county clerk's office, it looked like in 1967 a portion of the property was sold to Grow Green Chemicals and Grow Green Sales. We don't know what went on that property in 1967, but we think it's sort of reasonable to infer that potentially this property has been used for a similar type purpose for many, many years. And we know that up to not quite 1 acre, I believe it's almost 0.9 of an acre of this property, was sold to the L&N Railroad in 1881. So this 3.5 acre tract, for at least for traditional purposes, we believe has probably not been used totally for an agricultural purposes for many, many years. A church bought part of the property in 1960, I believe. We believe the current use of the property is consistent with the comprehensive plan which has been stated in Mr. Kane's report, and we believe the conditional use permit should be granted by this board. I know that there are people here to object and complain. In response to the letter of complaint which Mr. Kane mentioned was received in December, we tried to respond in our application to those complaints. We certainly have factual issues with some of the complaints we don't agree with. Obviously, people interpret conversations differently and see things differently. We're not saying anybody's wrong, but what I would like to do at this point, unless you have questions of me or Mr. Sweeney, I would like to sit down and see what these complaints are that I'm sure the people are gonna address, and then potentially, if, with the board's approval, have the chance, after they tell us what they want, they're complaining about, to potentially respond to those complaints. I have 2, maybe 3 witnesses who may wanna make a statement, including Mr. Sweeney. So at this time, if you don't have any questions, I guess of Mr. Sweeney or me, at this point, I'll sit down.
Any questions?
Thank you.
Okay, thank you, ma'am.
So,
Start at the top.
yeah, I guess.
Well, actually, I think Doc is here representing, Harold Sims representing some of the neighbors, so perhaps we need to start there, even if he is the last one to sign in, but. Thank you.
By the way, I'm not a doctor, so. The moniker that I've been blessed with for years. Members of the board, Mr. Perkins, my name is Harold Sims. I've been retained by Mr. Herschel Wiley, an owner of some adjoining property and a longtime resident of the neighborhood. Mr. Wiley is an elderly fellow and was very reluctant to get out on the roads in this type of weather, and I assured him that I would be able to convey his message to the board, and I've spoken with, in my preparations, I've spoken with several of the neighbors, and I will probably address some of their concerns as I move forward, but certainly am going to encourage them to speak their piece as well on this matter. We begin with by saying everyone to almost a T has indicated to me they're not here to try to put somebody out of business. And I've explained to them that these lawn and landscape businesses have been approved in ag zones as conditional uses in other parts of the county, but this is with the possible exception that it's not a listed conditional use in an agricultural zone. This fits the kind of the definition of what conditional uses are all about, is to take an otherwise unacceptable use within the zoning regulations and apply conditions to it that minimize the impact on adjoining owners, address the impacts on the environment, address the impacts on how the property is used and how it would affect the neighbors. So the conditions are what are important to Mr. Wiley, and the conditions are what are important to the most of the people I've spoken with. I guess I need to begin with the portion of one of the things that's a big concern is the conditional use does not relieve any applicant from otherwise complying with the regulations of our planning and zoning ordinance and our development plan. And I think in that, while we know that the salt dome is already built, I think this board has to examine whether now that the building is built, does it comply with the regulations for the placement of a building on a piece of property in this type of use. So while whatever we do here may result in a conditional use for this ongoing use, I think you have to examine whether or not there are buildings that may have been built under the scope of this use are consistent with the regulation plans. In other words, does the building meet the setback requirements? Does the building meet the conditions for stormwater runoff as a result of that building? I think it's important to note that it's not only the salt dome that's important, but it's the concrete pad and the paving of what used to be primarily a dirt lot is now all under rock and pavement, and the resulting impact on the stormwater runoff and the rate of stormwater runoff that results from those issues. There are concerns also with the meeting regulatory requirements and I think that's I guess, addressed generally in Mr. Kane's proposed conditions, but I've done I've had some conversation with the Division of Water, and while it's that they have indicated to me that a lawn and landscaping business is not a SIC code, whatever that means. I'm not going to be an environmental lawyer, but there's something called, when you look for stormwater permits, the first thing they look at is whether your business use fits under a certain type of code. It's called an SIC code. Their code number does not automatically kick in a stormwater permitting process. So then they look at whether the potential location of the property in relationship to waters of the Commonwealth, and there is an adjoining creek going by on the neighboring land, and the uses that's going on there and how it's being handled, could that result in a degradation of the waters of the Commonwealth? If so, then that would kick in the requirement to go through a stormwater permitting process. Similarly with the fuel tanks, my discussions with the State Fire Marshal's office have indicated to me that the type of above ground storage tanks that are in use on this property, and I have some pictures to share with you, we automatically got hit with, well, we had some change in regs in the last couple of years, so it depends on when they went into use. Well, they may not have been properly in use to begin with, but now there's regs that require that they be a certain number of feet from a building, that they have separate dispensers and not top of the tank dispensers, that they be so far away from property lines. And if you don't meet those requirements, you have to have a certain kind of 2-hour firewall, a containment area. And in all these tanks are supposed to be permitted. So I think there's some requirement. I think there would be some requirement. And obviously, that's a condition of Joe's plan. But I believe in light of the fact that this stuff is existing, it maybe makes sense to see where the regulatory agencies say, are they in compliance, are they not in compliance, do they need permits, not need permits, and instead of giving them approval right now and moving forward, let's see if they can get, wouldn't it make more sense for this board to require them to get approval or to find out if they're required to have permitting before we give them a condition that says you've got to have these things. Well, what if they're not under their existing configuration? They're not able to comply with those things, and then we're back up. So there's some concern on my part that the proper thing to do might be to get all the issues on the table here, and then table the result in this matter for them to go out and check with the Division of Water, check with the fire marshal's office to see if they need permits, and if so, what do they have to do to comply with permits, or at least make sure Joe's office is aware. I understand that in trying to get in touch with them since I got notice of this a week ago, trying to get in touch with them has been somewhat of a problem, so I can sympathize with his concerns there. But what I found out has led me to believe that there may be some problems with what's there. Now, I have spoken with neighbors who have some concerns about some other items that I think can be handled by conditions, as such as screening. A neighboring horse farm owner, when it was under the use of the previous owners, did not look out her back door and see a huge salt barn and 25, 30, or 15 to 20 cars a day, and plows and stacks of cages that hold fertilizer tanks, and that maybe would be remedied by a condition that you could impose upon the applicant to plant some screening across the line, her property line, so she doesn't have to enjoy that visual out of her back window. And I think that's part of what a conditional use permit is all about, is to minimize the impacts on adjoining owners. I guess at this time I would, if it would be appropriate, I would like to share with the board some of the the pictures about what I'm speaking about. Mr. Hearing Officer, would it be appropriate time to do that? And I'll share these with Mr. Gaines before I bring them to the board. I wanted to in relationship to addressing the positioning of the salt barn with the neighboring horse farm and the creeks adjoining. The smaller picture is the one I actually took with camera, and then I did a very crude blow up with my computer. This shows the positioning of the salt barn and its relationship to the adjoining property. You'll see in the smaller picture, you can actually see the creek. And then, if you'll note, also in this picture in the same field, there are several in this paddock right next to this property. There are several wet weather springs that just you happen to be able to see really well when all the ground around it was snow, and the wet weather springs were wet, so they showed up pretty good. The neighboring owners is somewhat concerned about runoff of the salt barn, whether it's from loading or whether it's from water coming out, getting in there. And as you can see, the adjoining owner is downhill from that property, and she's concerned about that runoff from that area going downhill. This a similar picture of a pipe headed next to the salt barn that's headed down the hill towards that area. I'm not exactly sure that if this pipe is intended to carry water, but it certainly looks like it's positioned to head over the hill. And I believe, I think Mr. Kane's report addressed the issue with the fuel storage tanks, but and it looks like a couple of these have the built-in containment system, and I think from the application they've indicated to me that the rest of them are double-walled tanks, which is certainly required these days by the Kentucky Fire Marshal's office. But from my discussions with them, it would appear that even with those precautions, that there's still some permitting, there's still some reviews, and under new regulations, the positioning of these in relationship to buildings is important. So it's maybe not just the type of the tank, but it's their positioning with relationship to right-of-ways and other buildings. There's some examples of some of the outdoor storage, of chemicals, equipment, and supplies that are in regular use on the property. And there again, we understand that they're not here trying to close Mr. Sweeney down, but these folks have lived in this neighborhood for a long time. There's always been business there, or have regularly been businesses there, and the previous owners have all come in and gotten conditions and approvals and have abided by the conditions that this board imposed. And the neighbors, be they new neighbors that have new concerns and new desires for protections or not, that's what the process is about. And so some of the neighbors may feel like, you know, I wasn't used to seeing salt barns out my back window. If they could be screened, that would be a nice condition that would is not an onerous burden on a landscape company, I would think, but it would certainly go a long way towards improving her line of vision to the property.
Just out of curiosity, how long has the salt barn been there?
And I don't know that it necessarily serves a whole lot of purpose to relive the history of the past, since he's been there for 5 years, and this point, but when he purchased the property, it's, real estate agents said that it has many, the property would fit many uses. It didn't necessarily say that it complied with all existing requirements for the many uses that they showed there. But more importantly, and what stuck out to me is that the advertising clearly indicated that what was going on there was a non-conforming use. They could have even put conditional use too, but what was there was a non-conforming use with the existing zoning. So whether you consider a welding shop light industrial, or you consider it consistent with agricultural, it was disclosed as non-conforming, and I think that would have been a clue to the purchaser that there may have been a need to look into this. I think I would encourage some of the adjoining owners that have issues as it relates to their particular properties, especially the folks that have horse farms that are served by the creek that may be downstream from the salt barn and from the possible storage of chemicals, to express their concerns to the board. And I'll take a back seat at this time and may have some further comments after some of the adjoining owners are through.
May I ask Joe a question before we move forward? And thank you. That one of my questions was, when was it constructed? 4 to 5 years ago. Do we know if the salt dome and the concrete pad, does it meet all the setbacks?
It doesn't look like it.
Okay.
It would be 50-foot setback.
Okay.
I'm not sure I wasn't sure if it would need a building permit.
That was my next question.
Yeah.
Does it need a building permit? Did they ever obtain a building permit? Okay.
They got one for something else over on the north side.
Okay. That's all I had.
The other people who've signed up to speak wish to address, I suppose we probably need to hear from concerned neighbors first, and then let the applicant and their witnesses. I suppose we need to hear from concerned neighbors first, and then the applicant and their witnesses can respond.
Then we go down the list.
Yes, yeah.
I mean, it doesn't say necessarily, but Rodney Nardelli lives on Payne's Depot, so I assume you've got something to say about it.
Yeah, I just wanted to reaffirm what Mr. Sims had said. My main concern, and my sister, we have the property across the street from Al, is that he's in compliance with the chemicals. The stream runs the length of our farm. And we have livestock there, and they water out of that creek. We also have a major spring that feeds into that creek, so that would be my main concern there. Al's been fruitful and multiplied, and is quite a lot of traffic coming in and out, but you can't begrudge somebody for success on that, I don't think. The concern is a safety issue with all that is coming in and out of that area. It might helpfully be resolved by enforcing the speed limit. The speed limit's 30 miles an hour, and we've never gotten any help out of that. But so that would be about all I have to say.
Have you had any specific problems with the water, or that you can tell us about to this point?
No, not specifically. We don't know.
Anybody had the water tested, or?
Never tested it. No, sir, we sure haven't.
Okay.
But I think just as a concerned citizen and
Never seen any foreign matter or anything that make you suspicious at any point in time?
like a foaming, some,
Yes.
occasionally there's a foaming in there, and the vegetation, a slime is growing into the creek, but I'm not an environmental expert.
But you have livestock that has
Yes,
drank out of this for a number of years. Y'all have
Yes.
been there, I know.
yes,
Okay.
we have. And to my knowledge, we don't know if there was any health-related problems or, to my knowledge,
Your livestock's been healthy and no major,
seems to have been.
okay.
Yep.
Susan Forrester.
Hi.
I have the adjoining property, and I am the one that outside my back window, door, swimming pool, I do have to look at the, his business, and the cars, and the salt dome. So, some days it bothers me, some days it doesn't. Just depends on what kind of mood I am, but I do, it is unsightly. And it is offensive to me a lot of times, but, Al has his business, and, that's his business. And that is my property with the wet water springs and the runoff. So it is a concern. In the beginning, when he first did buy the property, he wasn't as busy. There wasn't as much traffic, and there wasn't as much in and out. The salt dome wasn't there. So, if there is contamination in the groundwaters, and it is, then, it would only be right for him to be able to take samples, and, we need to know, because, I have livestock that waters out of that creek as well. Nardellis have more than I, because I'm on the upper end, and I've got creek up here, whereas they get the whole brunt of it. It may or it may not. I've not had any livestock issues whatsoever, but that would be something that I would ask it, is if we can, if the screening is something that falls into the conditions, then it would help me and stuff. It is unsightly and stuff, and now that he is parking his cars back in the back, I do look at a lot of parked vehicles of the employees. And I understand he's got to make a living, so do I. But that would be my biggest complaint, and also I have a right-of-way through that property that I have to have. I'm supposed to have access to it, which I don't. You have a lock gate, so I don't have a key to the lock, to the lock. So I don't know if that has anything to do with this, but it would help if I could have access to it, especially when the creek's full and I can't get to it. I did notice in the last couple of weeks where you did fix the road so I could get from my property up across, whereas before it was impassable only by foot.
Ma'am, key is no problem. You have
So,
access.
but I'm just saying, but Al and I have talked about this. I've said something to him on several occasions. And the only thing that I ever had a problem with, and Al addressed it, was in the beginning where they had emptied a salt truck, cleaned out a salt truck on the, it was on my property. It didn't end up, it was on the parking lot where he parks the cars. And the salt did leach down into my field and kill out part of the vegetation. And he did, I addressed it, he cleaned it up, and sowed some seed there. So, that's the only thing while he's been there, as far as runoff or anything, that I've seen has been detrimental. But, as you can see in the pictures, there's a lot of water. If there is stuff that's leached down into the soils and stuff, right now it's leaching onto my property and down into the creek. So, I think only rightfully so for all of us, that if there could be some conditions where, because of the amount of traffic that's in and out of there now, and you are a lot busier than what you were in the beginning. You have to admit that. So, and if there is a way that some sort of screening could be worked out, it would make me a happier person on a day-to-day basis. So I guess that's my biggest complaint. And the pictures show the runoff there, and there may not be an issue. There may not, but as protection to all of us, it would be good if we could, there could be some sort of something. But I guess that's all I really have to say.
Thank you very much.
Okay.
Yeah.
May I ask another question at this point?
Excuse me.
I have a question. What, I would assume as a lawn care business, in addition to the salt, you store herbicides, pesticides, that sort of thing on site, or do you not?
I can explain that. By law, all the pesticides and any chemicals have to be stored inside, and they are, it has to be locked. And it is, it's all inside, none of that is out. The mulch. You
But
see-
they are on the premises, right?
Yes.
Okay, that's what.
The mulch that you see in the photographs next to the salt dome, that's hardwood mulch, just like you put in people's lawns every day. And it's biodegradable. And I'm not sure that, I think it's sort of Alan's position that it's not really a contaminant that's gonna hurt the water. I think it's just, it's a piece of wood, basically, that's cut out. As far as well, I'll get into some other comments. Did I answer your question? I'll
You did.
hold up on the other.
You did. Thank you.
Thank you, Brent.
But those are, well, no, I'm gonna ask another one. But those are regulated, and as far as you know, pesticides, herbicides, the storage of are fairly heavily regulated. And you're in compliance with all the state rules for that as far as you know.
As far as we know, we're in compliance with, we've never been cited by the EPA, the storage tanks, the fuel tanks, we believe we're in compliance, and it's explained in our application. I think council's indicated that he's talked to some people, and there may be some new regs or something that may or may not affect us. It sort of sounds a little bit, don't get me wrong, we are willing to comply with all state and federal laws and to protect the storage tank. We don't want anything to happen in Ms. Morris's property. We don't want to, Alan's, the point is, we don't know any proof of anything that is out of compliance right now. We think we're in compliance with that.
Thank you.
Kim Nardelli?
I just have one thing that I'd like to maybe reinforce is the filtration berm. I think as far as us with the farm and our livestock, if we knew he had to do it, because we don't know that anything's happened, we don't know that it ever will, but we worry about it because there are chemicals up there. So maybe if there was some way that he had to comply with something that would protect an accidental spillage, an accidental whatever. Trucks, he is on a high point, trucks up on the high side leaking fuel, whatever, it is gonna get down into our creek.
Thank you.
Chris Wilkes?
That's one of my witnesses. Can we hold
Oh,
up on that,
sure.
please? Thank you.
Okay. I assume Judy Sweeney is one of yours?
Yes.
Okay, Michael Davenport?
Yes, he's one of mine.
Okay. Well, in that case, we're ready for you.
Is there
Now,
anyone else who
respond
wants to speak
briefly to
against?
some of the things council said.
Yes, they
First of all, I don't dispute anything that was said by, I'm not here to dispute what they said, but I do have a couple of comments. The pipe that council mentioned sitting there by the wall, it's not hooked to anything. It's a piece of old plastic pipe. It's not just sort of, he said it was trash, but it's sitting out there. It's not hooked on either end anything. It's just laying.
It is going toward the creek though, and it needs to be turned the other way or something.
It's gone, yes, sir.
Okay.
It's disposed of.
There are no fertilizer tanks. There's no fertilizer stored on in any tanks on the property, correct, Alan? Okay.
Some liquid fertilizer, there's some granular, but it's stored inside the lawn.
Is it bulk or is it bagged?
Bagged.
Bagged.
Yeah.
Excuse me, can I check something really quick before
Yeah.
you get into the rebuttal? Was there anyone else who had concerns that needed to speak?
It might be a good time for me to wrap up, and then he could, go. I just had a couple thoughts.
Sure.
After these guys got done. The concern with I realize that two things basically, and I'll sit down. Activities with the mulch truck and with the parking in the back, it's kind of the same thing as it relates to my first issue as to the board conditional use permit does not allow them to ignore existing subdivision development regulations. And we have regulations related to parking lots and how they're, and how you lay them out. And I'm not saying that I want a Walmart parking lot out at Payne's Crossing, but it's worthy of taking a look at to see if something can be done within the core scope of our regulations. If they have parking that's required, then should it not meet some of the requirements of our regulations with regard to that? If they're loading and unloading trucks, I understand mulch is, my purpose was not that mulch was a contaminant. It's just that there's an ongoing operation of trucks loading and unloading there, and is it appropriate? Is there something we can do to limit that use? They're obviously they've created a concrete pad which accelerates runoff, and that even if it is biodegradable, if it fills up a creek, if the runoff fills up a creek, that becomes a problem. If it prevents the normal percolation of the groundwater because of its running off into the stream, then and that maybe get back to the filtration berm, something to slow down the acceleration of the runoff. And then with relationship to the testing of the water, while they may never have been cited for non-compliance, I guess the bigger question is, have anybody ever checked to see whether they are in compliance? And I think that's part of the process that I would like to see as a condition, is that there be some effort made to make sure that this operation is satisfying all the environmental protection and state regulations that are in existence, rather than doing it and saying, well, they have to do it. Why not make them do it now before we grant it? With relationship to the trucks, I mean, I realize that the situation with the washing out of the truck, of the salt truck, was an isolated occurrence, which Mr. Sweeney kindly addressed when it was brought to his attention. But I have some other concerns about the trucks that haul salt day in, day out, and then they're brought back on the property, parked back there at night, possibly with their beds headed over the hill, and then it rains, and nature cleans out the truck. Where does it go then? So it's not necessarily a purposeful act of washing out that might be a problem. It's the residuals that may get washed out during normal rains that I think that you may be some concern. And maybe their salt trucks are covered at night. I don't know, but it's just a concern I had about something else that's going to result in unnatural products going over the hill into the creek and the groundwater. I think I'll sit down.
Thank you very much, Harold.
Just briefly, then if we'll try to answer any questions you have. I don't think Alan has any problem trying to be in compliance, and we don't have a problem with complying any state or federal law. But for example, and I don't want to be critical, but no one has gotten up and said that anything has really happened. Ms. Nadelli said nothing has happened. We don't know that anything's happened, and I think for you all to say you've got to go out and check this and this and this and this, when there's absolutely really no evidence that he's out of compliance with anything other than some comments that he may be by counsel, because he's talked to some regulators, and some concern. I mean, we don't have horses dying or anything like that. So my only concern is that before you grant the conditional use permit, Alan has to go do a bunch of stuff or get a bunch of reports that he ends up spending money on or whatever, which he'll be glad to do, that aren't necessary. Because no one has really come in and said the runoff's bad, there's been a storage tank violation or whatever. So that's my only concern. Just ask that you please think about that. Alan will do whatever this board thinks is the right thing to do, and we want to be in full compliance. But I just have a little hard time with, well, this hadn't happened, but maybe you need to do this. Go
Yeah,
ahead.
we can't get into this and that, but if you have some brief response that you want to add to
Yeah,
your
briefly,
comments.
Alan needs to operate his business, that's great. We have our business. Yeah, maybe nothing has happened, but it could be prevented. When it does happen and our livestock's dead, is he gonna pay for all my horses and my cows and my livelihood? I don't-
Attorney could answer
I don't
that.
buy that one at all.
It depends on what the extent of our responsibility
be
is to
prevented.
protect that. I mean, obviously, if that happened, I would think you'd have a cause of action against him, and yes, he would have to pay for your livestock if it was proven that his
But
runoff
my cause
caused
of
it.
action, he could never afford to replace my cause of
But
action loss.
the question is what the extent of our responsibility and jurisdiction is right now, and that's what we need to determine, I think.
May I ask another question?
You're perfectly free to ask whatever.
Thank you. The environmental regulatory compliance issues aside, we have heard testimony tonight related to screening of the salt dome. That seems to be a major issue with at least one, if not more, people. And that's not a regulatory issue. That's an aesthetics issue. Have you all given any thought to what you could possibly do to alleviate that, what some people would see as a nuisance?
Well, Alan, I'll have to let Alan respond to the screening because he's the landscaping guy. Maybe he'll
Okay.
know what to do.
Right.
The salt dome, I don't know what you folks want us to do because it's a normal, as you saw the pictures, it's just like right down there that the state uses. And it's got a concrete pad to keep the salt on, and the trucks are loaded on the concrete pad to our knowledge. And so I don't know what you all might have suggestions there about what to do. It's just a pretty normal salt dome. I'll let Alan address the issue about potential screening, okay?
Oh, could you, excuse me, but can you step up here when you talk, right?
Alan, you want to step up? I'm sorry.
Good evening. On the screening, well, let me back a little. We did build the salt dome actually after we had the instance with Ms. Forrester, and it was actually, we were storing it in a different building, and one of the guys cleaned it out. It was a mistake, so we cleaned that up. So that's the reason we built that dome, was because most landscape companies just pour it out, throw a tarp over it, and they call it good. And so we wanted to take care, we wanted to be neighborly, and we still do. We want to be neighborly in all that we do. So we built that dome so that no water would infiltrate the salt. It's covered, it's all backed in, it's taken care of. But as far as the screening, being a landscaper, we can plant trees. That's not a problem. If the board finds that is an issue that needs to be done, I feel like though it is kind of an aesthetics thing as well. But if you all find it favorable that we need to build some sort of screen as far as pines or arborvitaes, we can plant an evergreen screen along the property line.
I guess I appreciate the fact that it's probably unpleasant to look at. I wouldn't want to see what looks like an industrial installation out my back door, but the buildings have been there for a very long time. Is that right? Or
Yes,
did
ma'am.
And the only addition is the salt dome. Is that correct?
Yes, ma'am.
Okay.
Well, there's a substantial amount of parking back there as well.
Yeah. Okay.
That wasn't there.
I mean, I'm just thinking out loud, but I mean, it's not like this is a whole new installation. It's just the salt dome that's in the park and the additional trucks that are the annoyance,
Yes,
which
ma'am.
they would annoy me, I have to admit.
It's not, the buildings, yes, have been there and stuff. I mean, everything's been there, but like I said earlier, Al's business has grown tremendously. It's a lot bigger now than when he bought the property and started. But now, I mean, there are a lot of vehicles parked back there. And it is, I look on a parking lot and I look on equipment and stuff like that. So whereas, yes, the buildings have been there. And I bought the piece of property that I own now when the buildings were there. But there's a lot more traffic in and out of there and a lot more eyesore now than in the beginning. When Larry Wright was there, he didn't have as much traffic in and out or as many vehicles there as what's there now. So his business has grown, so therefore it's all back in the back.
So your request for screening relates as much to the vehicles as it does the salt dome?
just something to help block what I have to look at every day.
I believe that's all we have. I had other witnesses, but I don't think I need to call them from the standpoint of basically rebutting something. Unless you all have any other questions, I think everything's in our application. Thank you.
Any questions? Any other questions? I guess I have a question for you, Joe. I'm concerned about the potential dangers of runoff, just like anybody would be who lives, I have a farm on a creek and I worry about what goes on upstream. But is that not within the purview of the Division of Water rather than us to determine what's necessary? I just don't want us to overstep our bounds here. I understand we need to protect people, but I'm not sure who's responsible to do that.
I would think it would be Division of Water unless there was a development plan required and they had to meet our stormwater requirements, and then it would be us that would approve the plans and review them to make sure that there was, stormwater volume and,
Was a
didn't
development
increase.
plan of that type approved back for an earlier use? So there's never
No.
been a development plan approved?
No.
Is that in our jurisdiction? Did he answer you there?
Anna? Well, he said he thought it would be the Division of Water, but we're not sure because they haven't talked to
Well,
us about it.
I mean,
But we could put that in as another condition, specific, or not.
I suppose you, go ahead,
Well,
Joe.
without anybody asking a question, somebody said earlier, I guess it was Doc, the possibility of postponing it while Joe gets some of these callbacks. We could certainly put in any approval, a condition that at the very least notification be given to the Division of Water. I mean, as I recall it from years ago, it basically says if anything gets off your property and into certain bodies or running water, they have jurisdiction over you. So you could certainly put as a condition that contact be made, or you could direct our staff to make contact. We certainly can't make them do anything. I know through the years we've tried that with the highway department, but I'm not sure we've ever gotten a call back from any of it. So yes, you could make that a condition.
Okay.
Just in general, there's almost nothing that you can't make a condition as long as it has a reasonable connection with what the applicant is seeking to do and with a reasonable protection, screening, something, with the character and protection of the neighborhood. We don't want to get into Division of Water's job, certainly.
That's what I'm
But
trying
as
to
far as calling it
see
to their
what's what.
attention, requiring that contact to be made, although if somehow, I guess if we got to the point where Division of Water said, we're not interested, but there's damage being done, well, of course, we can step into that to some degree. So yeah, there's a number of things you can do. And in general, you can take reasonable steps to provide, reasonable protections. We can't come up with stuff that there's no indication is there. And we certainly don't want, to over, produce something, we don't want anything like that.
Yeah.
But as far as reasonable issues with reasonable protections, or again, at the very least, requiring notification to be given to the Division of Water. I think that can be done. If we were to give either the continuance to make some of these contacts, or if we were to give approval but conditioned upon those things, or at the very least, I think even without saying it specifically, conditioned upon things being as we understand them to be. And then 3 months down the road, come to find out there is something in the water, we can send a notice out, and even if Division of Water isn't showing any interest, I think we can look into that. Again, we can't take their place, we certainly don't have the expertise. But on the other hand, it is our obligation to allow reasonable use of the property, but at the same time, reasonable protections too.
I'm wondering how onerous, and I really don't, could you address the possibility of the filtration berm and how onerous that would be as just a protective device around the perimeter of the property in case there is a spill of any kind or a runoff of, I'm more concerned about the fuel tanks honestly than anything else, but.
And that's, you know, the filtration berm, to our knowledge, the 7 years we've been there, we haven't had an issue, like you said. But as far as, I mean, that would be, if our environmental came in, I mean, we would seek an engineer's advice, you know, because that screen can be developed in many ways. It's gonna depend on how much silt's in it, what type of rock and how much. And so, I would want to have it properly tested and then take the engineer's response, and we would certainly put that in if there was a need regarding the reports.
The only reason I think that it may be after the fact. I mean, you've been in business for some time. On the other hand, you know, we're now permitting, and with the conditional use permit and the fact that your business has expanded so much, it seems to me like that filtration berm might be a good thing to add at this point, if our attorney agrees that we can make that a condition.
I've always wanted to build a filtration berm. So if there's a reasonable basis to think that is, number one, not out of proportion to what's going on, and reasonably associated with the protections that are appropriate, of course you can do that. And we don't want to design one, certainly, but as far as, in effect, saying, you know, you got 60 days or something to come back with a preliminary study or something of how that would work, or if that's appropriate, I think that's fine. To give it to staff to let them review it, and then if it needs to be brought back, I mean, sure. All we don't want to do is get into the business of doing something we really aren't qualified, but we don't want to conduct something that's a reasonable protection.
Right.
And, you know, fertilizer and other kind, I mean, that's probably a reasonable protection.
Well, he's got all them under cover, and I'm not too worried about that, but I think a fuel spill is the most logical mishap, it seems to me, that would happen.
Yeah, the salt runoff too.
The salt runoff.
The water really needs to be tested somewhere.
Yeah, that's what I'm.
Somebody.
But now the other
As
question
soon as
I have,
possible.
what good would a berm do when you don't have a paved? The only pavement's the concrete under the salt dome, right? I mean, it's a gravel lot, so most everything is gonna go down anyway. I'm just thinking out loud.
That stuff's been driven on for so long, I can't imagine.
It's probably hard as a
It's
rock.
not as impervious as concrete itself.
Mhm.
Well, that could be.
And I don't know.
I don't have the expertise to address that, and I don't know who does around here.
But one thing that Johnny just said, that ought to be tested, that seems to me not that unreasonable.
Does that creek
or
go into
expensive.
Elkhorn? Doesn't it go on down and
Yeah.
go into Elkhorn?
Um,
Definitely.
So, I mean, that just seems like, again, whether that's as a condition on approval, with the idea that if things come back and it's not as we understand them to be, then further action can be taken, or if that's continue the thing for 60 days until something like that is done. I mean, I don't know, Jim, with your experience, you probably know fairly well how expensive and how, you know, owners have, I can't imagine it's that
It's not gonna be
expensive.
prohibitively expensive, but what you get with sampling like that is you get a snapshot in time.
Well, that's true.
And you know, you get a soil, a water sample today and you have it tested and it's fine, and it gets spilled tomorrow. So, you know, environmental monitoring as a rule, and I'm not suggesting we go this route, but just as a rule, it involves periodic monitoring, so that you don't get a single snapshot in time, that it's done every so often, based on what a regulatory frequency is set up. I'm not necessarily against arguing we shouldn't require that, but it does, the what you can draw from that, the conclusion you can draw from that is certainly limited to the time of the sample.
A sample of water clearly would be a very quick little snapshot, little Polaroid, as it were. But a sample of the dirt on the bank of that little creek, if it's been drawing stuff through it for some time, I would have thought kind of like a hair follicle test when the guys check in down at the CAPS program.
But probably you would have distressed vegetation if there were a lot of salt in it.
There would be some evidence of contamination already.
Not necessarily, but a good chance you would have distressed vegetation if it was it was contaminated.
Well, what
That's been
about
my
the berm,
experience.
do you think? You're the only expert we've got here.
I'm not supposed to be lending technical advice. I don't know. Fuel tanks, if they're truly in compliance with addressing fuel tanks in particular, where you have to either have under current law new tanks, double wall tanks, or containment berms that can contain 110% of the volume of the largest tank in the farm, that sort of thing, is the generally accepted environmental standard. And if I misstated that a little bit, please don't take me to task on it, but that's pretty close.
In trouble if you're
That's
wrong.
pretty close. The salt would concern me. Although the other thing, the good thing with the salt is even if you have a problem, it can usually be fixed. Salt flushes out, and you repair the vegetation. You go on. As far as a berm goes, I can support either way on that one personally.
Well, we've got this letter that's an exhibit from, I guess, a fuel supplier that describes the tanks on the property. Now, we don't know what the regulations are currently for fuel storage tanks, but there's 2 double wall tanks and the other 2 have basins under them, presumably to catch spills. So that seems pretty safe. I mean, you know, you've got
Southern
the.
States has got a big berm.
What we really don't know,
They have to.
but what we really don't know are standards for new tanks versus
Yeah,
tanks
right.
that get grandfathered
Pre-existing.
in. New tanks have double wall, or they have double containment, they have spill prevention on top, or if they're buried, they have leak detection, they have all these kind of environmental safeguards. But grandfathered tanks don't necessarily meet all those, not necessarily meet all those, and we don't know.
Well, I think just so, since we're just now getting the conditional use permit application, I don't think we would consider this grandfathered particularly just because it's been there.
No, I'm talking about grandfather from a regulatory
Oh, yeah,
standpoint.
right.
The same standards might not be applied.
Madam Chairwoman, from my conversation with the fire marshal's office, they also asked me the question, are they permanent or temporary tanks? And well, you know, they look like they can be moved, but they seem to be here for this man's use on his business. So, and I won't raise that because I think that's another kind of concern, is the tank designed to be something that can be moved around? That creates another, that's why I think it's, you know, the fire marshal's office could come out and tell you whether they're in compliance.
Well, we've got a condition in here that he's supposed to be in compliance with all regulations, so if that, and that surely would include the tank, right? Tanks.
Yeah.
I have one more question, just a matter of clarification, just simply because I have a feeling the question is gonna be asked by people, is that the first condition seems to be, states a premise that's part of the state statute on conditional use permits as well as our local ordinance, does not exempt the applicant from complying with all requirements of zoning regulations. So if something is not in compliance with the zoning regulation now and you allow a conditional use permit, does that mean that everything has to be in compliance, or are we giving it a pass tonight when we say yes?
I don't think we're giving it a pass.
No,
because
he
it
has
says
to-
No,
it
they've
does
gotta
not
come back,
exempt
it's
him.
gotta come back to us.
He's gotta be in
If
compliance.
he's not in compliance, he comes back to us. I don't know,
Yeah, I
say
think,
the water quality people found that it was really, or the ground around it was really
Yeah,
bad.
we
What
should-
would
we-
they, just
I
fine him, or
was
what would they do to
just
Al here?
asking a question and want to know how that.
it says does not exempt, he's still required to comply with all the regulations.
yes.
And if he's not in compliance, then we can shut him down.
I do think because of the increased traffic and increased parking, we should add a condition that the if we approve, we should add a condition the applicant work with staff to come up with an acceptable screening plan.
And I think he needs a burn.
You think it needs to be?
Yes.
Yeah, I do.
Sure do.
Okey dokey.
Case of a, I don't know what it
How
would.
much cost do you think that would entail?
Al probably know, he's probably. To put a burn around
To
there.
put a berm around your property where they're talking for the
Would it be
runoff?
very expensive to do that?
A berm?
Yeah.
I think it would depend on what the engineers,
the specifications of what they require. Because, I mean, they're gonna specify type of soil, type of gravel, type of sill. It should just be materials. But, so we're regulating whatever the engineers say, based on what they find.
There are lots for consideration. There are lots of concerns here, but there's no evidence of any damage at all at this point.
We're trying to stop that.
We're trying to prevent that.
That's what we're trying to do.
Well, okay, I'm gonna try to make a motion.
You're in charge.
I make a motion that we accept the staff report and grant approval of the conditional use on, with the conditions in the staff report, all of them, and additionally, that, there be a berm constructed according to accepted engineering practices around the perimeter of the property. And also that the applicant work with the well, no, I don't, that adequate screening be installed along the boundary of the property that is exposed to the rear inhabitants to diminish the effects of the view of the additional vehicular traffic. I don't think it's possible to diminish the effect of the buildings and the salt dome just because of the height of them, really. But I think screening to diminish the effects of the parking lot. And I think that's everything I want to
What
say.
about the water?
Oh, yeah, that's right. And that I don't know what to say about the water. I still think it's part of the Division of Water's jurisdiction.
Yeah, right, but
Yeah.
they need to be, is it in here? Is it
Well,
in-
they need to meet with all regulations, including the Division of Water regulations regarding runoff. So I'm not sure we need to add anything.
Who contacts them? Did Joe and them contact them, or do y'all contact them, or how's that work?
We can contact Division of Water, yeah.
I mean, if,
And see what they.
Yes, I think maybe that's a separate request, that you contact the Division of Water. Stay in contact with the Division of Water regarding this situation and make sure the berm is supposed to address
Right,
that.
right, I know, I
Yeah,
understand.
So I think
Should go
that's-
hand in hand.
Still, it
Should,
would.
yeah, right,
Yeah.
yeah.
but Just to be clarified, everything.
I know you made a motion, but I just want
Maybe I made a motion, I'm not sure.
The perimeter, when you say around the perimeter,
Uh-huh.
of his property,
pardon?
of his
I mean, that's
property.
hundreds of feet across the north property line when there's areas with nothing out there. What I mean is around the salt dome and around the area where the storage tanks are.
Oh, I see, okay, yeah, I can
There's
accept
just
that,
all in
yeah.
the back that's nothing but sort of
Yeah, right,
rock and dirt.
right. Mhm.
I just wonder if you could maybe clarify that to the areas.
I agree
of-
with that.
Maybe work with the staff to put the berm around the areas they're concerned with. If I could ask that.
I think that's reasonable, to have the berm around
Yeah.
the areas of potential contamination where there's chemicals and salt and fuel.
Basically just appropriate areas to protect adjacent properties, because it's not gonna go uphill, I don't think.
Right.
And a second question I've got, you also said, adequate screening to diminish the effect. One tree diminishes the effect.
Okay.
So and I'm pretty sure you don't.
There'll be a
mean
big
that.
tree ahead.
And it's not that I've got something in mind
How about
either.
alleviate the?
Well, because
But see,
it-
this is all a thing of aesthetics, so it's kinda hard to
Well,
say, you know,
it
how much
is,
sufficient.
and that's why, you know, I was thinking about, well, you know, to soften it and whatnot, or maybe to return it, you know, but I'm not sure we could even do that.
Our landscape ordinance has guidelines for screening between competing uses.
That's true, that's
Well,
true.
it does, and that's for new construction, and there's
Well,
not a whole lot of new
but
construction here.
that barn wasn't there when they bought this thing.
The what?
The salt barn.
Oh, salt barn, I thought you said the farm.
When they bought the property, it wasn't there. And the uses, and we're not looking, I'm not saying it has to, I'm not saying that the landscape ordinance is is entirely applicable here, but it's a standard that exists on our records that provides some measure of screening.
That's true.
As a
That's
community, we've adopted
Just default
this
to it.
for a method to screen between competing uses.
Is there not, do they not have special landscaping for parking lots? I mean,
Yeah, that's usually related to interior.
And that's related to public parking lots where the public's in
well,
and
is
out.
that not a public parking lot?
This is a parking lot for employees only. But
We do have perimeter screening for parking lots.
well, I think maybe we could use that as a standard, the perimeter screening for parking lots.
I mean, the buildings are large, so, I mean, I just need a little help. Just a little bit.
I mean, I'm not sure,
That's good.
we can, I mean, I think, it's not just you, it's any potential, I mean,
I know.
if it's
Yeah,
anybody, it diminishes the value of your property to a point.
And there are a lot of vehicles back there, and now it's grown tremendously.
Would a possibility be, one of the conditions to come up with, a screening plan, and whether they use the parking lot standards as a guide or just, you know,
Our experts
common
stand
sense
up.
or whatever else. And then at some point, bring the thing back, and you all take a look at that. I mean, just, again, we can't eliminate the site, but we can sure make it
Yeah.
a whole lot more acceptable.
Joe has something to say.
That's what I was gonna say. Rather than get in the middle of it, trying to figure out, you know, what's proper, what needs to be done, and maybe the applicant can come up with a plan for screening. We can give them direction on where to screen, and then maybe come up with a plan to protect the creek from any uses on the property, from any fuel spills or salt washing down off-site, stormwater issues or disturbance or,
And
problems with the creek. No, but I mean, maybe he can come up with a plan, or have an engineer, or have somebody come up with a
Agreed.
plan
And
for
if
screening. and-
If, for example, they come back with something and Joe says, that's just nothing, well, then
You can bring it back.
bring it back to here, and we can notify the neighbors and actually have a hearing on the screening plan. If it's submitted and it's quite reasonable, then it doesn't necessarily have to come back.
Okay, how's this?
Yeah, I agree totally.
Yeah, with regard to the screen, as the condition of the screening is that the applicant has 30 days to come up with a screening plan that he will submit to Joe, showing that there's adequate screening to address the concerns of the board. And also 30 days to come up with a berm, a protection plan against runoff that he will also submit to Joe. And if Joe determines it to be sufficient, adequate, then nothing more will be done. If so, then we'll come back. Those two in addition to all the other
Yeah, everything else is
conditions.
already on
Is there a second?
there. You don't want to tell them to paint the dome green or something?
Now.
Thought that.
I just thought that should be the thing, but anyway.
I second that.
Okay, all in favor?
Aye.
Opposed? Oh, aye.
Can I just read this to you to make sure that I?
Yes, you should.
Somewhere in the ballpark.
Mr. Minutes, yes.
All right, motion by the chair, second by Wade, to approve the application subject to the staff report, plus, that, well, let me skip down now. That within 30 days, they'll bring back a screening plan, which they'll submit to staff. And if staff finds that appropriate, then that'll be made part of this thing. And also within 30 days, they will submit a plan for a berm with adequate protection for adjacent properties. Again, staff looks at that and that appears to be appropriate, then it goes into the record. Any of that not be appropriate, it'll be brought back to you all, neighbors notified, and we'll go over whatever that piece of the thing is.
It's 30 days enough.
Yeah, that's what my question, is that enough time?
Do you consider 30 days enough?
Is that enough time for you?
That's just the question I asked Alan.
Okay.
Obviously, the landscaping and screening is something we should be able to do.
Mhm.
But I don't know if we get an engineer involved in 30 45 or 60 on the
90?
I'd give them 60 days.
60, yeah, 60, if 60, if you need more time, come back.
Thank you.
Yeah. I just don't wanna hold you up
Thank
right
you.
now, based on even though we are putting Joe back in the.
So how about we
things.
leave 30 days for the screening, but 60 days for the berm? Is that what I just
I
heard?
think so.
Yeah,
That'd be all right. Thank you.
so, that's my motion again. Is that your second again?
Second again.
All in favor?
Aye.
And hopefully you'll say that once I read it. All right,
Yeah, we're gonna have to hope this tape holds up.
very good.
Anything else with regard to this or any other matter? Thank you very much. We have, let's see, what happened to the agenda? I have lost it. Thank you all so much for coming.
Oh, I guess if people are leaving, and once the 30 days and 60 days and all are up, you all can give the staff a call and get copies of things, because they're gonna be public record. So,
Yeah.
okay.
Oh,
And the engineers and stuff, when are they coming?
60 days.
60 days for them.
I mean, the water purifier, I mean, the people that's gonna check the
Oh,
water.
they're gonna contact you.
Okay.
I don't know. Yeah.
Yeah, that'd be up to.
It's
Okay.
all on me. Yeah, I've been out there.
Oh,
See,
really?
they were all those farmers out
I know.
there. Mr. Wiley, 'cause he's 90 years old. Out there.
Why is he so close?
All right,
Huh?
we only had one other thing on the agenda, that's election of
He's on
officers.
Clear down the river.
Can't be me, so y'all go right ahead.
I was it before you were it, so I think I'm
But he
excused.
just,
No, you're not. You can be it again.
I've been
I think
it.
he's just
I've never
smart.
seen Anna so skinny as when she realized she
I've-
could
Ask him,
could do
he's
this.
just smart
I've
enough.
been
Oh,
it.
it's so hard.
I've been it before.
Did you not like that?
They don't like
Seems like you'd be good at it.
No, just because I sit here in the middle with her, no, on her left hand, no.
I ain't gonna sit there.
Do you,
Everybody's trying to pick the
Shoot, what are you
Anna.
talking about?
Cheers.
And I'm
No
sure
way.
your kid does a good job. He had it with
do I need to clear the room, or you?
No, we're
No,
just talking.
okay.
Nobody wants to do it.
I think she has done a tremendous job.
Oh, she
agree.
can't do it
Don't
another.
Does she
Don't
get
be
a?
emailing my wife.
Did you
and
bring?
tell her you don't
Did you bring the gold watch or anything? Brian?
No, I
Yeah, I
didn't.
want to.
Oh man,
did a beautiful job. Beautiful.
Joe! I thought we voted on that
I
last
forgot
meeting.
I forgot.
Thank you all very much. It's been a great pleasure. At least I wasn't chairman in the hardest thing we ever did.
I'm
So-
nominating Mr. Wade right here.
I second that.
There you
Okay.
go. You're
Okay.
in.
Mr. Wade, you've been nominated.
You've been nominated and been
seconded.
seconded.
All in favor, say aye.
Aye.
Okay.
You did a good job. You and Anna both. You did a good job.
How about a vice chair?
I nominate Mr. Whoever wants it. I'm not.
Wants it.
By the way, can I plug into that last one, that nomination ceased and
Mr. Wade?
Yeah.
Well, on the seniority.
Yeah, go
Mr.
for seniority.
Cannon, you may.
That's like a good idea.
Yeah.
Yeah.
I say Mr.
I'm the
Cannon.
bottom of the totem pole.
I nominate Mr. Cannon for vice chair.
Second that.
Okay.
All in favor?
Move nomination C.
This is like I've got. That's just what they did to me on running for this.
Right.
For this magistrate. That's the same thing.
Did they take you up there and sign your name?
Just about.
second, Johnny?
Second.
Yes.
Give me $50 to sign up.
You hadn't thought nothing about it?
Bobby Green signed. Oh yeah, I thought about it last year. I should have run last year, but Troy won, and I
All in
didn't.
favor, aye. Everybody agreed.
I
Okay.
didn't
Troy
know whether
didn't
against
wanna
Bobby
run.
and Troy now.
Bobby put him up
There
there.
being
I
no
know it.
further
And
business,
that's what
we
it is.
stand
You didn't go
adjourned.
out and work.
Right.